Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And oh boy, do I have another interesting video for you all. Today, I'm giving you guys an update on the Ripple v SEC lawsuit. To be honest with you, it is the most important and interesting lawsuit that I have ever been involved with, albeit not directly. And I think for a lot of you guys, it is too. Then again, we all can confirm and conclude too that it is quite difficult to get a good grip of the current affairs and situation. So I am going to give you guys a good summary of what exactly is going on right now and why these next couple of weeks are going to be so important. A long story short, there is a couple of things that have to basically conclude right now that are going to be the stepping stones for other decisions in the future. And exactly the next 2 weeks will mostly decide everything. All right. So, I don't know if I already said it, but my question of today was actually going to be, what country are you watching it from? But then again, I kind of thought, I should actually, because that's more akin to the video, ask you all if you're going to be buying some more XRP if we're going to see a dip pretty shortly here. Because, well, if the next couple of weeks are important, shouldn't it be smart to buy? I don't know about that, but I want you guys' opinion on that. And make sure you check out BITRUE for $1,600 worth of bonuses. All right, the SEC v Ripple battle continues, and the next 2 weeks could prove to be a decider in the long run as the battle for Slack messages continues. As the case evolves, the regulators seem to be shifting from whether XRP is a security to arguing that Ripple marketed it as one, thus the need for Slack messages. All right. So, to be honest with you, it's a pretty big story, but after we've read it through, I think you guys all understand the current state of affairs, and, well, it's just kind of a memory refresher and also a better explanation. So, ever since Jay Clayton, the former SEC chairman, filed charges of security violations against Ripple, the legal battle has become more intriguing by the day. In the latest twist, the SEC is attempting to lay its hands on internal communications by Ripple, and the firm is fighting against it. The next 2 weeks will be intense for both sides as the fact discovery deadline draws to a close. We know the SEC has been trying to get its hands on internal communications by the Ripple team, and as we reported on August 10th, the regulator filed an emergency order at the Southern District of New York seeking Slack messages by Ripple's team members. It claimed these messages contained critical and unique evidence against Ripple and XRP. Ripple filed its reply to the Slack motion yesterday, August 16th, opposing the move. Ripple has filed its opposition, and we talked about that in an earlier video. In its motion, Ripple claimed that first, the messages are not judicial documents and are not entitled to a presumption of public access. In addition, these messages could contain highly confidential material which reflect completely or competitively sensitive and confidential info concerning Ripple's business strategy, relationships with business partners, and internal business operations. Recognizing that the court may not entirely side with its motion to keep the information confidential, Ripple concludes by stating, should this court determine that there is no basis for sealing any of these documents in their entirety, Ripple respectfully asks for an opportunity to propose specific redactions be made to the documents. Then there is the battle for internal SEC memos. In the relentless fight to gain an upper hand through access to internal documents, Ripple has also been going after the SEC. Since as far back as March this year, Ripple has insisted that the regulator was improperly withholding relevant info, potentially exculpatory evidence. The SEC has been fighting back as well as it seeks to keep its internal documents to itself. Later today, the regulator is expected to file its response to Ripple's motion as the deadline hits, and what's most curious about the two parties is how late they have all left these important filings. Attorney Jeremy Hogan observes this in his latest video because August 31st, which is less than 2 weeks away, is the deadline for all fact discovery. Quote, I expect this to move very quickly this next week. Hang on to your hats because we only have a couple of days left, the lawyer, who is beloved by the AOL community, has said. Hogan further observed that the SEC has been conducting depositions without the documents it's deposing these witnesses about. And that is always a mistake, especially in federal court, when you're not likely to get a second shot at a deposition. Now, here's why the SEC is hell-bent on Slack messages, and it's a game changer. The SEC's motion lives and dies with the charge that XRP is a security and Ripple violated security laws. Or so we thought. But looking at the recent motions, it would seem that the SEC is gradually shifting its focus charges. Now, it's not just that XRP is a security, it's that Ripple marketed it as one. And while the two sound very similar, the second is specific on the company's actions, regardless of whether the SEC had issued sufficient guidance to cryptocurrency companies or not. Attorney Hogan believes that the SEC is changing its tone, as it can now see that it would lose if it continues to attack from a technical side of things. The argument here is that Ripple marketed XP like a security, treated it like a share of a stock, and tried to manipulate the price, he stated. This is the most evident in one of its recent motions, even though it's tucked away in the footnotes. On this, the SEC outlines whose Slack messages of Ripple it wants to lay its hands on the most. It includes 3 members of Ripple's marketing team, a telltale sign of the SEC's new attack angle, according to the legal expert. Quote, the missing documents, this is actually from a little bit before that, but still, the missing documents not only may be admissible a summary judgment. I've actually, by the way, concluded this all before, by the way, if you're wondering, Dusty BC is on the case, and if Dusty BC is on the case, you already get this info, a couple of days or a couple of weeks before the majority of other people get it. All right, so don't worry about that. But I've already read this before, and I've already checked the footnotes here, and we already concluded this. We already talked about this, so don't think this is anything new. All right, just make sure you understand that. Now, the missing documents not only may be admissible at summary judgment and trial, but are likely to refresh Ripple's employees' recollections at trial. This specific part, Ripple actually rebutted on, saying, no, it's not completely true. As an example, one person you had these Slack messages of still couldn't recall most things even though you had the messages, so that argument kind of falls. During the depositions, Ripple employees frequently testified they did not recall many critical facts. For example, Ripple's former CFO, Ron Will, stated he did not recall events in response to over 250 questions. Ripple's head of investor relations, Monica Long, did not recall answers to over 150 questions, and Brianne Manigan, who headed Ripple's XRP Global Markets team at the time of her deposition and whose missing documents Ripple refuses to search, could not recall answers to over 115 questions. However, the SEC was able to refresh witnesses' recollections using Slack messages. Had Ripple properly searched and produced all responsive Slack messages, they could have most likely regotten their memory a little bit and answered better. Now, the SEC proposed such custodians, all from Ripple's original list of 33, consist of the 14 Ripple deponents plus members of Ripple's marketing team, members of Ripple's XP markets team, and members of Ripple's finance team, and Warren Anderson, a Ripple engineer who worked with Swartz. Using Slack messages, the SEC refreshed Madigan's recollection as to individual defendants Christian Larson directive in 2020 that Ripple blank. Quote, now what does the marketing team have to do with whether XRP is a security or not? Absolutely freaking nothing. But it has everything to do with how Ripple marketed and created XRP, Hogan believes. Even more telling is that of the 38 information requests by the SEC, although a good number of these are generic throwaway requests, at least 12 or 13 of them are directly related to the marketing efforts by Ripple. Request number 6 instance states, all documents and communications concerning Ripple's efforts to promote purchases of XRP by retail purchasers and or speculators, including, but not limited to, communications with any retail purchasers of XRP and or speculators. All eyes are now centered on the SEC and its response later today, where it will argue against handing over its memos to Ripple. With the fact discovery deadline now less than a fortnight away, XRP holders and the larger crypto community will be biting their nails and crossing their fingers to see who lands what material between the SEC and its formidable opponent, Ripple Labs. Conclusion being, we got a good update on Ripple's side of things today. Over the next 2 weeks, a lot of stuff is about to happen. A lot of stuff is about to go down, and make sure you sit close to your freaking computer screen because once more, I think Jeremy Hogan called it Hell Week. I'm not exactly sure, but the next 14 days-ish, till the end of the month, 14 days, are going to be the most exciting and most devastating, most likely, out of the entire freaking lawsuit because things are about to get really hurried up. So from that perspective, yes, I'm excited. Yes, I'm bullish because I do believe Ripple will get most of the things that they can get out of it. They'll try to fetch. Then again, I'm also a little bit bearish on the perspective that the SEC is going to try to do the exact same thing. And we don't know which of the two is going to win on the short term. And since it's going to be the last thing, people might put some extra narrative on it, but ultimately it doesn't really matter. Long story short, decision has to be made on the part of Ripple, so whether or not they have to hand over these Slack communications, and the part of the SEC, whether or not they have deliberative process privilege and can hide all their information and documents. We have some specific dates for that, but let's just see, right? One more document is going to come today, and a couple days from now, the next one is going to be, let's just say a maximum like a week from now. Then some decisions have to be made regarding, for example, the motion to intervene, the motion to strike, motion to dismiss, all that stuff. There has to be decisions to be made. Yet the problem with that is that those decisions can only be made once that these two things are actually figured out all the way, specifically Ripple's request. So I'm thinking maybe those things will be figured out instantly after this one is fixed. Maybe there'll be another delay of this timeline, depending on whether or not the SEC wins. Because obviously, guys, if the SEC wins and Ripple has to look through all their documents, the timeline is going to be shoved back by another couple of months. And so that would definitely alter things quite significantly, like we read before earlier today. But yeah, afterwards, we all know how things are going to head on. Next 2 weeks, however, will be most important, so stay tuned. I had another kind of, I don't know, I wanted to talk a little bit more about the price, but I'm going to skip that for right now. I'm going to chill here, guys. I'm just going to chill, relax, sit down. A lot of stuff has happened. A lot of more stuff will happen most likely in the near future, but I think this is good enough for now, right? This is good enough an update. Make sure you stay tuned. Make sure you keep watching. I'll see you guys again in another crypto video later today.